Another one of the questions that we often get asked really early on in the process of people considering bankruptcy is, do you have to go to court? And the answer is, it depends. In most cases, a individual debtor is never going to have to go to court. An individual debtor will, however, have to appear for something that we call a 341 meeting or a meeting of creditors. And so the terminology can change depending on what attorney you're talking to, and depending on where you live in the country. And terminology, definitions, and all of those sorts of things are something that we're definitely going to talk about in the future. For now, the meeting of creditors, or the 341 meeting, is something that's held on Zoom, with your Chapter 7 or your Chapter 13 trustee if you're an individual. Typically, they only last about, I mean, 5 minutes for really simple cases, sometimes 15 or 20 minutes for more complicated individual cases. And to give you some sense of how things change, I was recently in a Chapter 11, Section 341 meeting that went on for about 7 hours. So with an individual case, it typically does not run that long. Even a fairly complicated individual case in which the debtor I was representing had a couple of businesses and had a number of upset customers, that one only lasted about 45 minutes, just to give you some kind of sense of how things tend to go. If you're in a Chapter 7 and you go through the meeting of creditors, typically that's the only thing that you have to do that's even remotely court related, and you won't see the inside of a courtroom. In a Chapter 13 case, that's usually also the case. If everything goes pretty smoothly in the meeting of creditors, you likely won't have to go to court as long as you're able to continue making your required plan payments, and you don't have any significant life events that cause a significant upheaval in your case. When comparing a Chapter 7 to a Chapter 13, the likelihood of going to court at least once is much higher in a Chapter 13 case. So in your ordinary Chapter 13 case, it oftentimes happens that the trustee will file a motion to dismiss your case. Those types of motions are usually about trying to make sure that you can comply with the terms of your plan and getting you back in line. Kind of, it's a simplistic way of thinking of it, but maybe like how you handle life with your children if you have children, right? If you want to create a better set of behaviors, then perhaps you make a threat for a specific consequence or punishment for certain behavior. And as long as they correct that behavior within a reasonable amount of time, they don't have that consequence. That's usually what the Chapter 13 trustee is doing. So, by way of example, if you're required to have your budget reviewed by your attorney once a year, and you don't get the information to your attorney on time, or your attorney fails to contact you on time, which can happen, the trustee may file a motion to dismiss. It's not that the trustee is after you. It's not that the trustee wants you to not be in bankruptcy anymore. The trustee wants you to do the budget review. If there are special circumstances that are stopping you from complying with the trustee, and your attorney isn't able to work out the details on those things with the trustee, we may have you come to court with us so that we can explain to the judge what's happening, but also have you available to provide testimony so that the judge can determine what the real facts are. Almost never does this result in you actually having to go up and testify. What it typically looks like is your attorney will say, If my client was on the stand, my client would say, this is true, and this is true. These are the special circumstances. And the judge can then, accept that as your testimony if there's no objection by the trustee. Usually, when we're talking about factual matters, there isn't going to be an objection. The trustee may have an opportunity to cross examine, but that happens so rarely that no person considering filing a bankruptcy should be concerned about going to court and having to do things that would make an ordinary person very, very nervous. So while there are possibilities, no matter what, because it is a court proceeding, that you would have to go to court, the likelihood of having to go to court in an ordinary Chapter 7 or Chapter 13 is very, very slim. Usually